You're listening to the AfricaMusicLaw.com show, Africa's premier entertainment law show empowering the African artist. And now, your host, attorney, speaker, visionary, game changer, Ms. Uduak.
Hey AML people, it is Miss Uduak. This is episode number 38 and it is our Ask Miss Uduak series, part of our Ask Miss Uduak series, and today we are covering the case of Robin Thicke and Pharrell Williams, actually the case of Marvin Gaye's estate, suing Robin Thicke and Pharrell Williams and T.I. The end result is a jury verdict for the plaintiffs, of which both Robin Thicke and Pharrell Williams have been ordered to pay a total sum of $7.3 million. Some news outlets are calling it almost $7.4 million, but let's just go with $7.3 million. T.I. is lucky because his record label that was responsible for the marketing and distribution of the music essentially walks away without any kind of legal liability. We will look at the facts, we will look at the legal issues created, and we will talk very specifically about the damages in this case. So let's start first with the facts of this case. It's pretty straightforward. In 2013, Blurred Lines was released, and there were two songwriters on it, Pharrell Williams and Robin Thicke. The song has made approximately $16 million in profits. When the song was released, the Marvin Gaye family sued the two songwriters, Pharrell Williams, Robin Thicke, and T.I.'s record label, asking for $25 million in damages. So, the trial went for 1 week. The case was in front of a jury. That's always interesting. If you're a plaintiff, you want to get that case in front of a jury, depending on the case, and especially in situations or cases like copyright infringement. If you're the defendant, you'd rather have the case in front of a judge or what they call a bench trial. So in this case, it's in front of a jury. What was the basis of the lawsuit? The Marvin Gaye family said, check this out. We heard that song. We heard the song Blurred Lines, and immediately we heard it. We said it has striking similarities to Marvin Gaye's song back in 1977 titled Gotta Give It Up. In fact, we are sure that is exactly the same, almost the same, and therefore we are suing because it's not fair. Because it's not fair for Pharrell Williams and Robin Thicke to make money off of our work without permission. We have the exclusive copyright to this work, so why do they do it without our permission? So what was the argument in front of the jury in terms of the copyright infringement? According to counsel, the attorney who argued in behalf of the plaintiffs, he claims that the bass was copied, certain keyboard lines, the hook, and repeated themes. And then, in addition, the plaintiffs say not only do they copy the certain elements that we've described, for the substantiation that they in fact copied is the fact that in several interviews that Robin Thicke gave, he basically said, let's write something like Gotta Give It Up. In addition, in several interviews also, Pharrell Williams says that Robin Thicke in the studio was acting like he was actually Marvin Gaye. It's so interesting because the defendants, so Robin Thicke and Pharrell Williams, come back and say, what are you talking about? Robin Thicke didn't really mean what he was saying. He was drunk and high while he was on Vicodin when he was in the studio making the song. And then with respect to what he told the media, according to Robin Thicke, he was basically lying to the media throughout the whole thing. So they said, don't believe what we told the media. Don't believe what happened in the studio. The only person that worked on the song was Pharrell Williams, and all the creativity essentially came from him. Believe what we're telling you now in a court of law, on a jury stand, having taken an oath to say the whole truth and nothing but the truth. The problem with that is when you tell a jury that you've lied, and when you said you've lied to the media, and when you also see you were drunk and high, credibility is at issue, big time. On a trial level, when you're dealing with the judge assesses credibility. But also assessing credibility is the jury, big time. So when you are telling them already that you can't be trusted because you're going to lie, how are they supposed to trust what you were going to say on the stands? we'll leave that to the side for a quick minute. Let's break down what the defendants actually made from the song. Typically, this information is not necessarily accessible to the public, but in this case, everything was like all open where you could really see this case and the analysis of it. Robin Thicke made $5.6 million from the song. Pharrell Williams made $5.2 million from the song. T.I.'s record label made $5 million, and then they had an additional $8 million in publishing revenue. Not bad, right? So we're looking roughly at approximately 10, 15, and then you've got 8, so we're looking at roughly about $23 million. It's no surprise then that the Gay family was sued for $25 million. Of course, they did not get $25 million. Now, let's talk about the copyright infringement. So first of all, we've looked at the facts. Now let's talk about copyright infringement. Before we address infringement, we must first understand what we mean by copyright, because without understanding that, we can't claim that there is an infringement. So what is copyright? Under the U.S. copyright statute, the 1976 Copyright Act, it's pretty straightforward. The right to copy. When we say copyright, the way to remember it is the right to copy. I always tell clients this. I tell when I'm giving seminars and speaking, the right to copy, that's all it simply means. Now, if you are one of those that really wants the key legal language, it says that when you create work that is quote unquote fixed in a tangible medium of expression, that work is protected under copyright law. So in English, it means the podcast that I'm creating right now, it's fixed in a tangible medium of expression. You can download it as an MP3. You can listen to it on iTunes. You can listen to it while you're driving to work or commuting. You can listen to it when you're in your kitchen cooking or whatever the case might be. It's fixed in a tangible medium of expression in order to be brought to you so you can listen to it. As a result, this work that I'm creating is protected by copyright law. So when you create your music, artist, when you create your book, authors, when you create your film, filmmakers, that work is protected under U.S. copyright law because it is fixed in a tangible medium of expression. And that's an important distinction, because if you're sitting down and thinking things and not acting on it, the law doesn't reward you. As a society, we like people who move our society forward. The law wants to encourage you to not just have ideas, but act on it. So leaving that and going next to discuss, now that we've defined copyright law, we need to say and discuss, okay, well, I have a copyright, but what does that mean? What power does that give me? Under copyright law, there's several powers, if you will, speaking loosely, that you are given. And they are basically 5 powerful things you can do with your copyright. Number 1, you can reproduce that right. So you can make copies of your protected work. So because the right is exclusive to you under the Copyright Act of 1976, you can reproduce your work, you can distribute your work, you can create adaptations of what is called derivative work if you like, you can perform your work, you can display your work, right? The right to perform your protected work, or you can display it in public. These are the essential bundle of rights that you hear people talk about over and over again, attorneys, non-attorneys, and generally. This is the bundle of rights that the Copyright Act gives to you as the owner of this work that you've created. So let's go back, recap. We understand the facts of the case. We've defined our copyright. We now have a bundle of rights. Let's talk about infringement. Notice I've not talked about the dates and times of expiration of a copyright. We don't need to get into that analysis. If you're interested in that, please visit podcast episode number 13. It breaks down a lot of those principles and even more. Now let's talk specifically on the issue of infringement. Was there copyright infringement here? And if so, then we go into the analysis of the damages. What is copyright infringement? Copyright infringement is using someone else's work without permission. Someone's created a work. I created this podcast. I own it exclusively. I've not given you the permission to create the work or do anything with it. I've not licensed it to you. I've not done anything to you. And you take my work and use it without my permission, and worse, use it for commercial purposes and make money off of it while I don't make any money off of it. that is copyright infringement. You need my permission in order to use my work, with the caveat that there are exceptions to this rule, the exception being fair use doctrine, which in this instance, we're not talking fair use. Fair use is not on the chopping block. It's not part of the analysis today. Maybe further cases or future cases, we'll see fair use come up. So let's stick closely with the facts and the legal issues raised here and get to it. So in talking about infringement, because you have all this bundle of rights, and someone here, in this instance, the Marvin Gaye family is arguing, you didn't have a right to use our work. Now, several things I want to discuss when it comes to copyright and your ability to sue for infringement. It's critical under U.S. law that if you want to sue for infringement, you must register your copyright work. So that's really critical, that in order for you to sue for infringement, you must register your work. So as a recap, just so you understand, number one, to create a copyright, your copyright work must be fixed in a tangible medium of expression or broken down. That means it has to be original, have creative intelligence. It must be fixed in a concrete form of expression. We covered what that means, and that ideas are not protected if it's in your brain. You got to put it down on paper and let the law step in once you do to protect you, and put it down on paper, MP3s, what have you, right? The next step is, okay, now you're claiming someone has infringed on your copyright because you have a bundle of rights. Well, how exactly have they infringed on your copyright? And the first thing first that I said is you have to understand that you must register your work, because when you register your work, number one, it will put the world on notice and give legal presumption that your copyright is valid. Secondly, if you're going to sue or bring an infringement action, you must register your work. Third, the significance of copyright registration is that it also makes it easy to sue and recover. For example, if you have a timely registration within 3 months, or even the registration within 5 years of your published work, it's going to strengthen your case when others infringe or violate your copyright. If you register before your rights are infringed upon, the fourth reason why is very important and significant for copyright registration, you can recover up to $150,000 and possibly your attorney fees when you sue. And the beauty about it is you don't even have to prove your actual monetary damages.
You're listening to the AfricaMusicLaw.com show, Africa's premier music business and entertainment law show, empowering the African artist.
All right, let's wrap up our analysis on this blurred line case. I mean, it turns out to be a pretty blurry case, of which the jury is like, look, it's too blurry. Next time, keep it nice and clean. And here you go, a tab of $7.3 million. Well, how did we get there in terms of the $7.3 million? How is the jury determining what is owed to the plaintiff? Whether you're a plaintiff or a defendant, what you should know is that if a plaintiff sues you claiming intellectual property infringement and specifically copyright, they have to prove damages. In every case you will file, with the exception of criminal cases, and even with criminal cases, there's something called restitution, where the victim wants restitution and will still have to go into court and prove those restitution damages too. So practically, a court of law is aimed at remedying you, helping you to get back to where you were before someone hurt you, in simple English. And that's the whole point of damages. In this instance, what law governs copyright damages in accounting? It is 17 U.S.C. Section 504. That body of law governs the recovery of damages and profits when we're dealing with copyright infringement action. So now we know what law governs. The next question is, we've got to ask, well, what exactly does the law do? What the law does is it says, plaintiff, if you prevail in a lawsuit, we're going to allow you to basically recover 3 kinds of ways. The first one is you can recover what's called an injunctive relief. So you can tell the court, hey, Your Honor, the jury have ruled in my favor, so I'm going to ask you to give me an injunctive relief to basically allow me to go to the defendant and say, you're creating blurry lines. You need to stop selling or singing my song because it's an infringement. So that's the part of what's called an injunctive relief. The other thing you can do as a plaintiff is you can opt for what's called an actual damages and profits. What does that mean? Your second way that you can recover. Under the statute that I quoted, and even more specifically, Section 504B, so 17 USC Section 504B, the copyright law essentially says, look, plaintiff, you can get actual damages that you suffered as a result of the infringement, and any profits that you can show is attributed to the infringement that were not taken into account when we were calculating your actual damages. So we calculated your actual damages, and it did not include the profits that we can directly attribute to the infringement that occurred here. How does the plaintiff prevail in showing the actual damages? So what must the plaintiff prove? Number one, the plaintiff has to show that the defendants, in this case, Robin Thicke and Pharrell Williams, made certain gross revenue. So, hey, they made $16 million. So that's what the plaintiff must prove. Let's look at the defendants. What do they have to prove? What does Robin Thicke and Pharrell Williams have to prove once we reach the part of damages? What they're going to say is, okay, yeah, we made 16 million or 23 million or whatever that amount is, but we had so many expenses deducted that we only made 1 million after all was said and done. So really, Your Honor, Marvin Gaye's family should only get what the court determines is appropriate of $1 million, not 16 million, not 23 million, because we essentially only made $1 million. So the point is that it's a dual burden for both parties. When all is said and done, we should emerge with the defendant's net profits. And once we get the net profits of Robin Thicke and Pharrell Williams, then we pay that to the plaintiff, Marvin Gaye's family. All right, so we've looked at two formats so far. We talked about injunctive relief. We then talked about the second option of actual damages and profits. Let's wrap it up finally with a third way of recovery, which is recovery under the statutory damages scheme provided by Section 504 of 17 USC. And what that says is that the law, the statute, permits what's called statutory damages, so damages by law, which essentially means that the law gives a range of what you will get. It's already prescribed. The law says if you, the defendants, so Robin Thicke here and Pharrell Williams, infringed on the estate of Marvin Gaye's copyright, or the plaintiff's copyright for short, then the plaintiff can recover certain enhanced statutory damages. And particularly, the court will also look at if the infringement is willful. The court will not allow the defendants to subtract those expenses we talked about before. So their federal income taxes, overhead expenses, or certain other expenses. That is it from me to you. Hopefully it's been helpful. Don't forget to subscribe via iTunes, or you can also hear us via Android. Certainly pass it on and share with as many people as possible. Share with our community of artists and other creatives. And when in doubt, get a lawyer. That's what lawyers are there for. If you have specific questions for me, please email me at africanmusiclaw@gmail.com. In addition, if you have your specific case that you feel you'd like to bring to my attention, you can contact me at my law firm email address, and that's Uduak, Uduak, at ebitulawgrp.com. It goes without saying to everybody listening that this is for informational purposes only, and there is no attorney-client relationship formed by virtue of listening to me on a podcast that's for everyone in the world to listen to. And again, if you have a specific scenario specific to you, please feel free to contact me. Otherwise, until the next Ask Miss Uduak, we shall talk later. Take care and have a great rest of the day. Cheers, people.